is just to replace the figure 7 with 14. That would then mean count 18 would be or refer to a date and a place as mentioned in count 14. This in accordance with the cluster of counts as presented, my Lord. If the court so pleases.
Thank you. Counsel?
The court pleases, my Lord. It's been discussed with me. I've got no objection. There's no prejudice for the accused. The amendment can be made.
Thank you. The court then orders that count 18 be amended as to read that it is a reference to count 14. 7 is deleted, replaced with 14. Now, before I continue with judgment, I received lengthy heads from both counsel, heads of argument, and I had a lot to think about. So this means that we don't really have to canvass any issues today unless there are some specific things that the council would still want to add. This is a factual matter, and that's why maybe we also receive these very long heads of argument. And it's no use going into all the facts again and arguing about it. Your heads, I must say, your heads were excellent. I was very delighted when I saw the very professional way in which it was done. But I must say also that thanks to iAfrica's transcriptions of the whole court procedure up to date, that helped a lot too with the factual situation. It's such a good way to have a record that's been typed on a daily basis, or as they say, on a running roll. And just a last remark, I always tend to deviate a bit, but I saw in the heads of the state where they referred to Exhibit 3 as being provisionally allowed. I had a look at the record. It has been finally allowed, so that we can just confirm that. Volume 10, page 758. So before I start with judgment, if there are any other matters or something that counsel for the state or for the defence might want to add.
Thank you, my Lord. The state has no further arguments, save for that contained in the heads of argument. That's the court pleases, my Lord.
Thank you.
I'm in a similar position. Thank you, my Lord. I've got nothing further to add to my hands.
Thank you. I'm not going to read the whole of the judgment. The judgment will be handed down a bit later. I'm going to deal with the main topics, the main issues. I just ask or make an order that the typed judgment be part of the recordings of this process, and it will be given to iAfrica transcribers at the end of the trial. I, in any event, mark one judgment with an X as part of the court file. Now, the accused, Mr. Lindri Kaku, has been accused of 18 counts, as set out in the indictments. He pleaded not guilty on all the accounts. He elected not to make any clear explanation. There were a lot of formal admissions entered into by this court. The state called 16 witnesses. The accused testified in his own defense and called 3 other witnesses, and that means the defense had 4 witnesses. I'm not going to go through the summary of the witness evidence. It will take too long. As I said, it's part of the judgment, which is to be part of this record. But I might just say that in this judgment, I talk about 5, let's call it scenes, scenarios, clusters, 5 events actually makes up this whole 18 charges. And I quickly want to name the 5 so that we are at item about them. This first scene, scene 1, cluster 1, or whatever, is about the shots that were fired in the street. Shots fired at Andre Mooi and Ronald Plaatjies. The second scene is the events that occurred at the street party. I'll call it the street party. That's where Smith was hit with a bullet in his back. And then the third scene is the shooting of Alton Mooi, who was killed, and the wounding of Shane Williams. And that happened at or near the corner of Percy Petter and Michael Rupert Streets. It's close to the, shall I call it, the infamous, I don't know why you have that name, but G-Spot Liquor Store or G-Spot Club. So I'll be referring to that as well. Scene 4 is the incident that occurred near Brandhof Street. That's perhaps the smallest scene, if you want to call it like that. That's where a gun was pointed after a famous fight, which I now learned the term fago is the term for a street fight. So that is scene 4. Scene 5 is the killing of a toddler, sorry, Luke Tibbetts, and injuries to Keenan Mokuna. Now, that happened in Statler Street. As I said, I'm not repeating I summarized the witnesses, the defense case, and having done this, I must say that the first conclusion that I came to is that the accused was correctly identified at each of these scenes. He also placed himself at some of the scenes. There are court cases that I quote in my judgment, referring to what a judge must look at when you judge the identity. There are many factors to consider, but I am convinced that the accused was at all 5 scenes. And I give my reasons in this judgment why I say it. I may just first of all also mention that I had a good look at Advocate van Eck's referral to discrepancies. So I had to go according to what the court cases says about discrepancies and contradictions, especially with statements that witnesses made. The bottom line is that this court finds that the discrepancies are not such as can be seen to discredit the evidence of a particular witness in toto. In this case, I again referred to authorities. Eyewitness memory is a very interesting subject. I've, through the years, always loved to read about how valuable witness memory could be and how if it could really lead you astray or not. It's interesting that there are some specific conclusions that psychologists have made about memory, and I'll just mention it for interest's sake, that your memory becomes much better if the event is unusual, or the event could be important to a specific person, or it could be an event that a person is emotionally involved in, But the studies showed that with dating there could be a problem. A person don't always remember dates, but you do have a good recollection of what happened, and you actually attach your recollection more to people, location, circumstances. And if people want to date memories, they have to write it down when the event occurs. So you have to like have a journal, a diary or something. That's just a sideline. The next issue before I come to the specific charges is that there was a bit of a worry. I thought there might have been a bit of a new type of law created in a recent case, although recent means 2012, but time flies. In 9 months' time it will be Christmas. But in State versus Fulani, the impression was created when you deal with the Firearms Control Act that it should be proven by experts. So in other words, even if 4 witnesses sees a person with a gun, the state will still have to call an expert witness to say it was indeed a gun. Now I deal with that and I try to evaluate and see what the court reasoned in this case. But my opinion is, as I said it in this judgment, is that this isn't a new law or new case that says in all cases you must get an expert to prove it. Council can read my reasons why I say it, and I'm not going to. What I might just say is in that case, in Fulani, the judge in any case said, even if I was wrong, I am of the view with respect that the state need do more than to prove that a bullet was fired from a weapon. So he doesn't really say, he says, even if I was wrong. So I don't see this case as being new law. He says, even if I was wrong, I think you better get an expert. But he also says, he leaves it open for other courts not to follow him. Now, in this case, the arguments from both the state and the accused were received, and I will deal with that now. My interpretation of the Fulani case is not that ballistic experts should be called in for each and every case, although it would make it easier. But if on the argument the state could prove that an unlicensed firearm must have been used, as this is the only inference that the court could make, coupled with the evidence, then ballistic evidence would not be necessary. In Fulani, the court was very cautious by stating, even if I was wrong in this. Each case has a unique set of evidence. Now, I then go on to give a summary about the firearms and why I come to the conclusion that in every count relating to firearms and ammunition, the case proved, the state proved its case, although I am not going to say the case did that in the matter of count 13. That's that after the Fago event. A gun was pointed, but there's no proof that it really had ammunition in. We can take it, and the court wants me to just say, well, this was the way the accused used to operate by having ammunition in his gun, but I'll give him the benefit of the doubt in that case, in that count 13. Now I will now look at each cluster. Let's look at scene 1. That's where Mr. Plaatjes and Mr. Mooi were complainants. and they testified about the incident that occurred on 5 January at Andre Mooi's girlfriend's house late at night, and they both confirmed that they knew the accused, and as I said, I don't think they made a mistake of identity. Mr. Mooi is well known in Westbury as well as the accused. The question is this: did the accused shoot at them or not? The accused took out a firearm, he fired, he threw him, and when he fired, Mr. Mooi said he threw himself next to the vehicle. And Mr. Mooi testified about the hole in the wall. The police attended the scene. There were 2 cartridges found. Mr. Mooi saw a bullet hole because it was still like raw, he said. It's a hole he never noticed before. And Mr. Plaatjes corroborated his evidence with regard to the intimidation and the identification of the accused. The accused version was put to Mr. Mooi, namely that the accused was never involved in any sort of altercation where a firearm was used to discharge the 2 shots. And then there was a second version that Mr. Mooi was framing the accused because of the murder of his brother. But as we saw, this particular first scene happened 5 months before his brother was killed. And I may just already at this stage say about the accused, when he testified, one cannot fault him to be a liar in all aspects, but he was not convincing in this court. And in this case, the state also procured 2 reliable witnesses and also further corroboration by the police, finding 2 spent cartridges on the scene. The accused, when he testified, he gave new versions throughout, and this will be seen in this judgment as well. And the court cannot really say that some of the versions were never put to the witnesses. Now, having a look at the famous Busak case, the Supreme Court of Appeals, per Judge Schmalberger, went really haywire about why don't you put the version. The court must make negative inferences about this. Then the ballistic evidence in respect of the spent cartridges, coupled with the fact they were found, makes this court to believe that the evidence presented in respect of count 1 to 3 is sufficient to sustain a conviction in respect of all 3 the counts. Cluster 2. He was at the street party. He denies that he had a gun. The state witnesses, Smith and Bowes, who were the DJs there, they said no, they saw him with the gun, and the fact that the shot was discharged and that Smith was indeed hit by a bullet, which is still in his back, shows the firearm was used. The witnesses, there's one point that is relevant, and that's that the witnesses did not see the accused discharge the shot. However, they say that they saw the accused in possession of a firearm, and they also testified about how Smith and Bowes had a fallout and how they are no longer friends. So this excludes the possibility that these witnesses, especially Bowes, harbored a motive to lie. The probability that someone else had fired the shot is nullified by the evidence of Smith that after the shooting, and that's very important, if the accused did not shoot him, why visit him in the hospital afterwards? And although this was denied by the accused, I must say, but why visit him in hospital? What's more, and I'm not going to go into too much detail, is the accused appeared in the magistrate's court, and Smith was asked to attend it to talk about the bullet that's still in his back. Who's going to, the accused wanted to financially support him in this, to help him remove the bullet, provided he withdraws the charges. The version of the accused is the fact that in his evidence in chief, he denied that he ever spoke to Smith again after the shooting incident. During cross-examination by the estate, the accused confirmed that he never spoke to Smith or his mother when they were at the magistrate's court. But then he alleges that the Smiths had spoken to his family. That was a version that has never been put to Logan when he testified. On the proven facts, the court inferred that the accused was indeed in possession of a firearm. He had discharged the shot that injured Logan Smith. The evidence presented does not prove that the accused acted with the necessary intent to kill, as is required when you have a count of attempted murder, and that's why the court will look at the negligence and the firing of a firearm. The accused said he did not possess a firearm, nor did he fire a shot. But the only reasonable inference compatible with the objective facts is that he was indeed armed with a firearm, and it is my opinion that the elements of the first alternate count to count 4, negligent firing of a firearm, not attempted murder, that was proved, and count 5 and 6 were also proved. The accused was not licensed to possess a firearm. Now, looking at cluster 3 is the scenario near G-spot. The questions to be answered here is, we know that it can't be reasoned away someone was killed. Someone was badly hurt when he ran away and shots were fired at him. So the question is, who fired the shots? Or did only one person fire the shots? In other words, who fired the shots that killed Moy and injured Shane Williams? The accused denies that he had a firearm on that day, and he fired any shot at or near the crime scene. Now, I must say that at this stage, it's very good the way that we've received technical evidence in this trial. It helped tremendously, but I think the introduction of CCTV footage and technical evidence is a very, very handy tool for courts. It even helps that at one stage I was thinking of doing an in loco inspection, but with CCTV footage. And I must say, if you Google street maps too, you get a good idea of what things look like. So next time we might even have a Google street map on, then we don't have to go to the scenes itself. But okay, There's just another thing. We were looking at the scenes where the accused was running and wondering whether he had a gun or not, at scenes where they were talking, and it seems to me a lot of fingers were shown, signs shown. Now, the better way to look at your CCTV footage is not on a big screen, but on a laptop actually, or a computer. The pixels are better, the images much clearer. The images reflect behind. Now, why I say this is when you make it small, it's beyond all reasonable doubt when you see the accused running with a gun in his hand. One cannot, a child will tell you that man is running with a gun in his hand. It does not need an expert to see this. This places the accused, of course, near the actual scene, coupled with the evidence of Mr. Ronald Williams, the ex-policeman. Now, what also appears to have happened is that it would appear that there were more shots fired at Shane Williams when he exited G-Spot from the back. Okay, I'm not talking about the first, but there's something that he said, well, I ran away, ran through G-Spot, and then as I went out, I heard more shots. I will not go into that. I don't think it's relevant for this case. So I'll leave it there. Now, one thing that Advocate van Eck in his heads argues correctly is that, or shall I say inter alia, one thing, is that Ronald Williams cannot be reckoned as a firearm expert just because he used to be a policeman. So if he said the gun was empty or cocked or whatever, he's not really a firearm expert. Now, I agree with that, but there's also a place for logic in the sense that, yes, he's not a firearm expert, but he was there. He could see if this guy had a gun in his hand or not. And I think because he was a trustworthy witness, together with the CCTV footage, this accused did have a gun in his hand. He was at the scene, he heard the crash, he ran to the scene, he heard shots, and like he said, then he ek het brieke aangeslaan, so he put brakes on, he stopped when he heard the shots, and then he saw the accused running with a gun. He doesn't need to be an expert to see that. The evidence of Major Mankena in respect of the fact that the firearms that had discharged spent cartridges found at the crime scene were indeed firearms as defined in Section 1 of Act 60 of 2000, coupled with the admission made by the accused that he is not licensed to possess a firearm. That to me renders proof of counts 9 and 10. But looking at the evidence contained in Exhibit D and F, the medical reports of the deceased Elton Moy, the ballistic evidence that was collected at the crime scene, coupled with the evidence of Lunat and Williams, shows that whoever shot acted with what we call dolus directus, or with the necessary intent to kill. Not to fire warning shots, not to fire in the ground, but if you take all this evidence, it was intended, the shooting was intended to kill. If one looks at the Yaris, the door full of bullet holes, that confirms the intention. But still the question to be answered, who fired the shots? Now, the shooter who fired at Moy and Shane Williams, one of the shooters, were outside the vehicle when he fired multiple shots whilst firing at his targets. 14 shots were fired from the same 9mm firearm at close range, hitting the deceased in a manner as described as in his post-mortem report Exhibit C. Now, in the post-mortem report Exhibit C, we also see Shane Williams was struck twice by the person who was standing outside the car. The evidence cannot be interpreted in any other way than that the shooter acted with the sole and direct intent to kill Moy and Williams. The deceased, Mr. Moy, as well as Mr. Shane Williams, were not armed or did not fire any shots at the Golf. It was not the version of the accused that he and or the other passengers in the Golf acted in private self-defense and or in a manner that can be described as putative private defense. Well, it boils down to self-defense. The accused testified that now remember they were coming around the bend. When Moy's car hit the Golf, he just saw lights and that caused him to jump out of the car and run away because of shock. The evidence clearly confirms the evidence of Shane Williams. So the accused confirmed him in a sense that Moy accidentally crashed with the Golf as it stopped suddenly. It was never the version of the accused that the crash was a deliberate assault by Moy on the Golf and its passengers. And why I'm saying this is there's always this underlying story that people were fighting, were hating one another. Moy shows signs, the accused shows signs. There's forever this underlying thing about being cross with one another. But let's look at Yusuf Lunat. He testified that the person who entered the Golf at the left front passenger seat at G-spot, that person was the same person who had fired shots at Moy and Shane Williams around the corner. This was also the person who chased after Shane Williams whilst shooting at him. No shots at the shooting scene were fired after the shooter and Williams had turned the corner running back in the direction of G-spot. Now, the surveillance footage in Exhibit 1 corroborates the sequence of events and the events itself as testified to by Lunat. The evidence of Shane Williams and Ron Williams confirming the events and the sequences of the events, especially that within seconds after the shooting, Shane Williams turned the corner, turning back in the direction of G-spot with the left front passenger of the Golf following him. The accused admissions that he was the left front passenger in the Golf, and after the shooting he did run around G-spot. That corroborates Lunat and Ronald Williams' versions in all material respects. The evidence of Lunat that the left front passenger of the Golf, that's the accused, that fired multiple shots whilst being outside the Golf, confirms the evidence that the accused was the one who shot at them. Advocate van Eck is of the opinion that Lunat cannot be believed due to the mistake about the accused's clothing, and I do give him credit for that. But then again, as I said, with the help of technical video footage, it's very clear that he had a gun in his hand, running with his arms stretched. Now, the accused version contains many improbabilities and deficiencies. And I would like to just quote Mr. Advocate van Wyck's heads of arguments. He sets out the improbabilities. The fact that the version of the accused was never put to Lunat, Shane and Ronald Williams prevented them from answering such a version. This creating the inference that the exonerating version of the accused is a fabrication. The fact that the accused made no effort to report this incident, that is on the assumption that he was innocent, directly points towards his guilt. The submission is made against the backdrop of his own evidence that he opened a case against Shane Williams in February 2014 for attempted murder. And the court may add that the version that he fell as he got out of the car, and that's why he ran with his arm stretched, that is blatantly false. Now, again, I must quickly come back to the ballistic.
That is the Luke Tibbetts trial. We're going to come back to it in a short while, but right now let's take a break.